Hello, everyone. My name is Michael Misko. I'm a healthcare attorney, and I'm pleased to welcome you to this week's edition of Kyra Secures Growth Without Risk. Today, we're going to talk about a new regulation that has generated a bit of buzz. It's the 21st Century Cures Act regs related to information blocking and the access, exchange, and use of electronic protected health information. Now, this is different than the Health Insurance Portability and Accountability Act. It does not modify HIPAA. It in fact creates separate additional requirements separate and distinct from HIPAA. This regulation, the final rule went into effect yesterday. So if this is the first you're hearing about it, you're potentially a little bit behind, but not to be worried. Hopefully, your electronic medical records vendor is on top of this, but you do need to check and make sure that they are. I want to begin by indicating that this regulation applies only to electronic medical records. So if you are a practice that documents on paper, you don't care about the disincentive payment under Medicare for not adopting certified EHR, you hate computers, whatever your reason is, this does not really apply to you. Now, for those of you that are completely cash practices and therefore do not meet the definition of a covered entity under HIPAA, in which HIPAA doesn't apply, but you nonetheless document your services in electronic medical records, it is very likely that these regulations do apply to you because, as I pointed out, this is a separate an unrelated regulation to HIPAA. So the HIPAA does and the Cures Act do two different things. The Cures Act was passed in 2016 under President Obama. The regs are just coming out now, and they impose essentially requirements that are designed to do two things. One, update the certification criteria for electronic health record systems. That's done through the Office of National Coordinator, and there's pages and pages of information about the guidance that they're going to use. There's 2014, 2015. You don't really need to concern yourself with that. What you do need to be concerned about is that your EHR system is designed in such a way that it prevents information blocking. And while I don't want to bore you with an overly technical definition of what that means, it is defined in the regulation. So except as required by law or covered by an exception, which there are exceptions in the regulation, it's a practice that is likely, not practices in you have a chiropractic practices in an act or an omission that interferes with the access, exchange, or use of electronic health information. And um, there are other requirements for health information technology developers relative to providers. If the regulation continues by suggesting that if the blocking practice is conducted by a healthcare provider and the provider knows that such a practice is unreasonable and likely to interfere with, prevent, or materially discourage access, exchange, or use of health information, you got problems, and there are big fines authorized under this particular statute and accompanying regulation. Things where you're allowed to block as required by law only pertains to interferences with access, exchange, or use that is explicitly required by state or federal law. And the most common example of this is there are certain psych records that the law explicitly protects. Those are allowed to be blocked, but I don't know of any explicit bylaw protection that would apply in the chiropractic realm. Now, the Act defines electronic health information, which has a very similar definition to electronic protected health information that you find in the Health Insurance Portability and Accountability Act regs. And I don't want to spend a whole lot of time on HIPAA, but just understand it's essentially the same thing. It's The only limitation is electronic health information is EPHI, or electronic protected health information defined under HIPAA, that is contained in a designated record set. And I'm not even going to go into, the laborious definition of what that means, but essentially when you store information in a patient file in a particular format, that is a designated record set. If you store documents in a Word file on your computer, that is not a designated record set. So, so if you have, if your idea of electronic health information is you type your notes in Word, or you dictate them in a Word document through Dragon or something like that, that's not a designated record set, and you don't have to worry. Now, critical to information blocking is understanding terms that I've used several times, and you need to know what they mean. And those are access, exchange, and use. Access means the ability or means necessary to make electronic health information available for exchange or use. So we're going to have to define those terms again. And I hate when they use defined terms in a defined term, but because now you got to understand all three to understand what access means. But you have to, a patient, for example, or another provider has to have free access to your health, your electronic health information. That doesn't mean unrestricted. It just means they have to be able to get to it. So you can have reasonable safeguards to prevent inappropriate disclosure. But for example, through a patient portal, a patient has to be able to access their electronic health record, or they can authorize someone else to access it on their behalf. And that's where things kind of get tricky with HIPAA, where you're talking about TPO, treatment payment healthcare operations disclosures, for which an acknowledgement is necessary, is all that's necessary, versus non-TPO disclosures for which an authorization is necessary. And you have to delineate, is the patient, accessing the information, or is a third party accessing the information, based upon the authorization of the patient. So that gets a little tricky. So there is some HIPAA and Cures Act overlap that you have to work out in your mind. So if it's been a while since you've analyzed your obligations under HIPAA relative to TPO and non-TPO disclosures, TPO again meaning treatment, that's information that you share among providers. So if you get a request for information from another provider, you don't need an authorization. They shouldn't be asking for one from you. And to the extent that you both have electronic systems, and that request is an electronic request for information based on the portability components of HIPAA, you don't need, if you were trying to stop that requiring an authorization, that would potentially constitute information blocking, because HIPAA doesn't require an authorization for a treatment disclosure. Payment and healthcare operation. Payment is what allows you to send claims to an insurance company, and you only need the patient's acknowledgement of your notice of privacy practices, specifically acknowledgement of, quote unquote, air quotes, receipt of your notice of privacy practices. It can be posted on your website. You can print it out and give it to them, but they have to have the opportunity to review that somehow. That is what constitutes receipt, or your good faith attempt to obtain their receipt. So if you got a patient, I don't want to sign anything. Let's say it was a PI patient or whatever, and I'm not signing anything. That's fine. You document a good faith attempt, and you have the acknowledgement you need for TPO disclosures. The O in TPO is healthcare operations. That's when insurance companies request records either for a prepayment audit, post-payment audit, utilization review, things of that nature, information that you share for pre-certs. Those would all be Even pre-certs would potentially be payment as well, but those are requests that come from an insurance company. So those are TPO disclosures. Non-TPO, for that access, you would have to have. So if the request came from someone other than the patient, you would need the patient's authorization to disclose that information. If that someone wasn't a health plan or another provider. Exchange means the ability for EHI to be transmitted between and among different technologies, systems, platforms, or networks. So, and this is where your EMR vendor becomes, significantly critical. Insofar as you have certified EHR, then that system has to be capable of freely exchanging this information in an electronic form that is readable by another person's electronic medical record system. And we'll get into some examples of, what is or might not, or what might be or might not be information blocking to help flush out some of these definitions. But um, let's just get through them for now. Use means the ability for electronic health information, once accessed or exchanged, to be understood and acted upon. So if you were to send electronic health information in a electronic format that the recipient couldn't read, then that would be problematic. That would be information blocking. Understood is defined by the Office of National Coordinator to encompass as encompassing the ability to comprehend various features such as structure, content, and meaning of the information. But it is not intended to mean that the person is going to understand the clinical significance or relevance of the information. So if you're popping out diagnosis codes or test results, and the patient doesn't understand, let's say it's going to the patient and they don't understand what that stuff means, that does not constitute information blocking. That's just, one of those things you got to go to doctor school and learn, or look it up on Google. So you're not obligated to explain the clinical significance of the information for the patient, but they have to be able to to read it. So there is a definition of use under the HIPAA privacy rule at section 162.103. ONC considered using that for consistency, but rejected it because the one that they chose was a little more suitable for their information blocking rules. Now, there's a number of things where information, is appropriately accessed, used, or exchanged. And that's what this rule is intended to promote. So sometimes if you understand what they're trying to do with this rule, it makes it a little bit easier to understand what you might have to do to comply with it, to the extent that you do. My guess is that many of you are going to call your EMR vendors and say, okay, here's this new rule. Does your system comply? And how can I be certain of that? I wouldn't take it on faith and say, "Oh yeah, we're cool with a 21st Century Cures Act. Don't worry." And then a patient, tries to get information they can't. So you're going to need to know a little bit about the rule to validate whether your system actually is in compliance or not, because that is your obligation to ensure that it is. So I would not necessarily take your EMR vendor's word for it. Have them walk you through it. How does a patient get access? How would another provider get access? How do we, exchange information? How does that process work? What does this information look like when we exchange it? So that you're certain that you're not likely to be challenged as an information blocker. So the so If you're in compliance with the rule, you would be able to provide patients with access to their EHI, that's electronic health information, as well as the ability to exchange and use it without special effort. And this is where things get a little tricky. I mean, of course, under HIPAA, the patient has a supreme right to not only obtain access, uh, download, obtain copies of their own protected health information, they're also free to do whatever they want with it. So if a patient obtains their records and they decide to publish them in the New York Times, totally fine. Now you can't do that, but they can. They can do with their records whatever they want. But you have to provide them with the ability to exchange and use their information without any special effort. Now, special effort gets a little dicey. I mean, might they need some training or something about how to use a patient portal to access their records? Yeah, they might. But that wouldn't necessarily be considered special effort. They wouldn't have to hire a programmer to say, for example, recompile information or get any special tools, get a license from your EMR vendor to read the information. That would be special effort. You also need to ensure that healthcare providers, caregivers, other authorized persons have the EHI they need when and where they need it to make treatment decisions and effectively coordinate and manage patient care, um, and can use the EHI they receive from you, as well as other sources. Similarly, as healthcare providers, you should have the ability to access and review records. So the patient had an MRI, you should be able to get online and get that information freely and without restriction. You want to get records from their family practice doc, you should be able to get online and do that. That's what this is designed to do. Um, Ensure that healthcare providers can access, exchange, use EHI for quality improvement, population health management activities. I don't know how much of that you're going to do, but you're supposed to be able to. You're supposed to be able to ensure that payers and other entities that purchase healthcare services can obtain the information they need to effectively assess clinical value and promote transparency concerning the quality and cost of healthcare services. Now, this is where things get a little dicey because now we're mixing a couple of concepts. Um, they need to have access, and the question comes, when does that right of access, and this is where these rules are a little fuzzy and cause me significant concern because being in the post-payment business, we deal with requests for information from payers very cautiously. One, okay, HIPAA has a requirement that they're only authorized, to receive a limited data set, and you have to determine how to limit the data set under your obligations under the minimum necessary disclosure rule. And that assumes, of course, that you have a legal duty to provide the records in the first place. My concern is that, when a non-par payer, okay, requests records, okay, um, and or you're non-participating, you have no contract, no obligation to participate in their post-payment utilization review efforts, and normally we resist the documentation request on that basis. HIPAA may permit you to disclose that information, assuming that they've stated the purpose of the request, you can meet your obligations under the minimum necessary disclosure rule, and all of that stuff. This rule suggests that they should have free access to do a magical mystery tour in your system relative to services that they've paid for. And that creates some pretty significant challenges because now you're going to have to, in theory, create pathways to any third party payer. For any third party payer that you submit claims to, so that they can access the EHI relative to those claims. And this rule, and I have to spend more time studying it, is not jumping out and telling me the when or the timing that this right of access exists. So we may have to do a follow up on this. But this is one of the more troubling aspects of this rule, because If we block them off because we have no legal duty to provide that information after payment was made, even before payment is made, you could say, hey, we're submitting this claim on behalf of the beneficiary. Make your payment decision. If you want records, we're not sending them. Well, that may be considered information blocking, where your records are stored electronically. So if you're running a cash practice, this is a really good reason, or you're a non-par provider, and don't want to become subject to this, any allegations of information blocking, now would probably be a really good time, to go back to paper. And I'm not suggesting you necessarily dump your EMR system, but this is going to create obligations for you that, may compromise, our ability, to resist post payment audit efforts in cases where you're non participating. If you're a cash practice and you don't submit any claims, of course, that issue is not going to arise. You have to support access and exchange of EHI for patient safety and public health purposes. Um, Practices that increase the cost, difficulty, or other burden of accessing, exchanging, using EHI for these purposes will almost always implicate the information blocking rule. Now, this is potentially horrifying because this suggests that the government, should have free access to all of your healthcare records for patient safety and public health purposes. Um, I don't know what those purposes are. Contact tracing, who owns guns. I have no clue what they want to do with this. But anytime you got the government snooping around in your records, that, it gives me cause, for concern. Fees charged, by actors, which would be you, to assess, exchange, or use their EHI is inherently suspect as constituting information blocking. So, um, it's generally recommended that you not charge. Okay, so that's, kind of like what they hope the rule is going to do. They do outline, throughout their comments, some things that are likely to interfere. Formal restrictions such as, licenses or contract terms, sharing policies, intellectual property or other rights, as well as informal restrictions, that, um, cause you to, uh, refuse to exchange or facilitate access, is likely going to be a violation. And again, I bring up the commercial payer wants to do a, utilization review on services they paid. They have no contractual right to do it. We have legal defenses to stop them from ever recouping. But this suggests that if you have EHI and you resist that request, that's likely to be a violation, and they can come after us and force disclosure, uh, under this Cures Act regulation. Limiting or restricting interoperability of health IT, such as disabling or restricting use of a capability that permits users to share EHI with other systems, or configuring technology so that types of data that may be exported or used is limited, except as required by law. So, if you were a psychologist or a psychiatrist and there's certain information that you needed to block from being accessed, fine. That would be a restriction. There are some other exceptions. I'm not sure we'll have time to go through them all, but, think about this. I mean, in theory, you have to create these portals or these, the ability to export this data. You need to pretty much export everything. Well, think about, let's say you have, an insurance company wanting to access EHI, and your EHI contains records associated with services that the patient paid entirely cash for, and for which the patient signed a restriction on uses and disclosures. So, this concept is the interplay between HIPAA and the Cures Act is going to create some conflict, and I don't have an answer yet, on how that's going to be resolved. We'll have to see how that plays out. impeding innovation and advancement, such as exclusionary, discriminatory, other practices that impede development, dissemination. These are things that an EHR vendor would do to protect their quote unquote proprietary databases. I mean, if the government truly wanted to um, enforce interoperability and data sharing among EHR systems, they should have come up with a standard data set so that every EHR system operated out of the same database. They did not do that. And there are export formats like HL7 and a number of other things that, in theory, allow data to move between systems. Those don't always work very well. If you've ever been through a software change, whether to billing software, EMR, and of course you want the new vendor to migrate your old data. Even if they agree to do it, it never turns out right. It's always a disaster. And similarly, information sharing does not work very well unless it's between the same systems. This is probably going to force EHR vendors to go back and retool. You're probably going to see updates that they're going to make you buy. I would not that I'm beating up on software vendors. I used to be one, but if you haven't gotten an alert that you need a new update and the cost is X, you don't have support. You need to get support. So, I mean, this is going to be an income opportunity for EHR vendors, but not because they're being jerks, but because they have to comply with this. Opportunistic pricing practices, rent seeking, artificially increasing cost of an expense to access or exchange or use EHI. That's probably not going to hit you, but again, EHR vendors, licensing fees, things of that nature, they need to be cautious in that regard. There are some others that aren't going to apply to you, but I've highlighted some of the ones that give me the biggest cause for concern. We're almost 30 minutes in, and I've covered most of what I wanted to cover. Just I want to address two exceptions, or there are two types of exceptions: those that apply to when you're not fulfilling requests, and ones for those that do. The most important one is the patient or preventing harm exception. This allows for reasonable and necessary practices to prevent harm to a patient or other person, subject to certain conditions, and you have to have a reasonable basis that the practice, meaning the restrictive practice in terms of not releasing or blocking access, will prevent harm to another patient or another person. That belief must be reasonable. You have to do a risk analysis and document heavily. There is going to be a lot more that is no doubt going to be published by all kinds of people about this, but think about reviewing your understanding of HIPAA. Think about the interplay between HIPAA and the Cures Act. I've alerted you to a couple of issues that are giving me some angst and frustration. Contact your EHR vendor, have them walk you through how does a patient get access, how does another provider get access, how would a health plan get access, and we'll see how that starts shaking out, and then watch to see if you get any of these requests. I mean, they're creating this ability. It'll remains to be seen how well they educate, especially your patient population, as to their ability to access their own information. In the medical world, patient portals are pretty common. I don't know that that is the case in the chiropractic or PT world, but look to your systems, talk to your vendors, and come up with a plan for how you're going to comply. That's all we have time for today. Next week, Dr. Janice Hughes will be here. I'm sure she's going to have something very exciting to talk about. Thanks for your attention. Sorry this went a little long, but it's a big topic. Everybody have a great rest of your day.